Welcome to Legal on Demand, powered by Maguire Legal. Conversations on law, business, and the decisions that matter. I'm Sonia.
And I'm Edda. In this episode, we're unpacking a listener question from Victoria. Can a workplace record both video and audio, including inside meeting rooms?
Now, it's actually a deceptively simple question because once you look at the law, there are multiple layers to it.
And also, depending on whether we're talking about video or audio, the answer can be completely different.
The starting point is the Privacy Act 1988 Common Law. Any recording of an employee, video or audio, would generally be personal information under Section 6 because it identifies an individual.
Which means employers are subject to the Australian privacy principles. Things like collecting information only where it's reasonably necessary, notifying individuals, and using the information for the purpose it was collected.
Exactly. That's when we get to the employee records exemption, which is where a lot of confusion sits.
And because people hear exemption and assume it means no rules apply.
And that's not correct. The exemption is limited. It applies to employee records once they exist and relate to the employment. It doesn't override other laws and doesn't give employers unrestricted rights to record employees whenever they choose.
So the Privacy Act sets the framework, and further restrictions come from state and territory laws. In Victoria, the Australian Capital Territory, and New South Wales, they all have their own specific legislation, while the other states and territories do not have dedicated workplace surveillance legislation. Employers in those jurisdictions still need to comply with broader privacy and surveillance laws.
Exactly. And in Victoria, the key legislation is the Surveillance Devices Act 1999.
And this is where we need to get really clear on what the law actually says.
Yes, because the Act defines a private conversation as one where the parties desire it to be confined to those present or where the circumstances indicate that expectation. So it's not about location, it's about reasonable expectation of privacy.
Which means a conversation in a workplace can absolutely still be private.
Exactly. In practice, many workplace conversations will meet that definition, particularly HR discussions, performance reviews, disciplinary meetings, or strategy or management discussions.
So, once something is a private conversation, what does the law say about recording it?
Under the Surveillance Devices Act Victoria, it is generally unlawful to use a listening device to record a private conversation unless all parties to the conversation consent. There are very limited exceptions, but for employers, the safest option is no audio recording without consent.
Let's apply that directly to meeting rooms because they are one of the highest risk areas for audio recording. If an employer records conversations in a meeting room without informing participants and obtaining consent, that is likely to breach the Act.
Even if the meeting is work-related, the fact that it's work-related doesn't remove the expectation of privacy.
So, what about a situation where a workplace has cameras and microphones running continuously in meeting rooms? So, basically, everything is recorded by default.
That's where the risk becomes much more serious. If those systems are capturing audio, then you're almost certainly dealing with recording of private conversations. And as we've said, recording a private conversation without consent of all parties is generally unlawful.
So, even if the employer has a general policy that says meeting rooms are monitored, that doesn't automatically make it lawful.
No, and that's a critical point. A blanket or continuous recording approach does not override the requirement of consent. Consent needs to be informed, specific to the situation, and given by all participants. A general policy in an employment handbook is unlikely to be enough, particularly for audio recording.
And in practice, meeting rooms are exactly where private conversations are most likely to happen. So, think about performance management, meetings, disciplinary meetings, salary negotiations, and even strategic or commercial discussions. They all occur in meeting rooms, and there is a reasonable expectation that these are private conversations. So, Sonia, if a workplace is recording everything by default, what's the actual exposure?
There are a few layers of risk. First, a statutory breach under the Surveillance Devices Act, which carries penalties. Second, employment law risk, because if that recording is relied on in a dispute, it can undermine the employer's position. And third, reputational and trust risk. Employees may feel like they're being consistently monitored in a highly sensitive discussion.
And it also creates a practical issue because consent isn't static. Even if an employee signs a policy once, that doesn't necessarily mean they've consented to every single future conversation being recorded, particularly where the context changes. So, what would a lawful version of this look like if an employer did want to record meetings?
It would need to be far more controlled and transparent. For example, recording is not continuous. Participants are clearly notified at the start of each meeting. Consent is obtained before the recording begins, and participants have the option to decline.
So, the difference really is between passive surveillance and active consent based recording.
Exactly. An always on system, especially with audio, is very difficult to justify under Victorian law. A case by case consent driven approach is much more likely to be compliant.
And from a governance perspective, it also makes much more sense because even if something is technically arguable, the real questions for employers should be, is it proportionate? Is it necessary? And also, how would this look if it's challenged?
So, if your meeting rooms are recording everything by default, that's not just a technical setup, it's a legal decision, and one that needs to be carefully reviewed, particularly when audio is involved. So, when can audio recording actually be lawfully done?
Well, there are a few scenarios where it may be permissible, and that's where the employer has gained express consent from all participants. They've clearly notified everybody at the start of the meeting, and there's ongoing consent where recording is a known and accepted practice.
So, something like a Teams meeting that announces that it's being recorded is a good example of transparency and implied consent through participation.
What we've discussed is on the basis that everyone consents, but what happens if someone refuses to be recorded?
That's where employers need to be careful. If recording is not strictly necessary, the safer approach is to proceed without recording. But if it's necessary, for example, regulatory compliance reasons, the employer may need to 1. Offer alternatives such as written minutes to consider whether the participation can proceed without recording, and 3. Assess whether refusal is reasonable in the circumstances.
So, after everything we've said about audio, particularly how strict the rules are, it's important to note that video surveillance is treated differently.
Yes, and that distinction matters, where audio recording captures the substance of private conversations and triggers stricter legal protections. Video surveillance is generally viewed as less intrusive because it captures conduct rather than what's being said. If employees are clearly notified and the purpose is legitimate, for example, security, safety, or protected property, video surveillance is likely to be lawful.
So, things like cameras in reception areas or open plan offices are common and generally acceptable when they're transparent and proportionate. Where employers need to be careful, though, is when video starts to shift from security into closer monitoring of behavior, particularly if employees are not aware of that use.
So again, it comes back to purpose and transparency. Even with video, the questions are still, why are we recording? Have we told the employees? And is this level of monitoring proportionate to the risk we're trying to manage?
There are also areas where surveillance is simply not allowed.
Yes, both legally and from a risk perspective, surveillance is strictly prohibited in areas where there is a high expectation of privacy. This obviously includes bathrooms, toilets, or change rooms. Even video surveillance in these areas would be unlawful.
That makes a lot of sense, doesn't it, Sonia?
Obviously, let's talk about policies because this is where employers often think they're covered.
Policies are essential, but they need to be detailed and specific. And a compliant policy should include things like what types of surveillance are used, whether it's video, audio, or even IT monitoring. where the surveillance occurs, the purpose. So, is it for security, safety, or compliance? Maybe all of those. Whether audio recording occurs and how recordings are stored and used, and also what the obligations are for the employees.
And most importantly, whether consent is required.
Spot on. So, when should consent be obtained?
For new employees at onboarding and as a part of the employment contract and policies. But for existing employees, before introducing new surveillance changes and with clear written notice and acknowledgement.
What happens if an employer already has surveillance in place, but then realizes that they haven't properly obtained consent?
That's a really important scenario and one we're seeing more often as businesses review the practices. If surveillance, particularly audio recording, is already occurring without proper consent, the first step is recognizing that this is not something that can be simply fixed quietly in the background. The collection may already be non compliant, particularly under the Surveillance Devices Act, where private conversations are being recorded without consent.
So, it's not just about updating a policy and then simply moving forward. Consent needs to be introduced prospectively, not retrospectively. And you also can't cure past non-compliance by asking employees to sign something after the fact.
In that situation, there are a few practical steps employers can take. First, pause or review the surveillance activity, particularly where audio is involved. Second, provide clear written communication to employees explaining what surveillance is currently in place, what is being recorded, video, audio, or both, where it occurs, and why it is being conducted. Third, seek informed and express consent, particularly for any audio recording.
And informed consent means employees genuinely understand what they are agreeing to. So it's not just a clause in a policy, but it's a clear explanation. It's also an opportunity for them to ask questions and also provide an acknowledgement in writing. And importantly, the consent must be specific to the type of surveillance, especially where audio is concerned. So, Sonia, what if an employee refuses to consent?
Well, that's where it becomes more complex. For video surveillance in common areas, refusal may not necessarily prevent the employer from proceeding if that surveillance is lawful, reasonable, and properly notified. But for audio recording of a private conversation, refusal is much more significant because the legislation requires consent of all parties.
So, in most cases, the employer can't just override that refusal. And from a broader perspective, there's also a trust element here.
Absolutely. If employees discover that they've been recorded without their knowledge, particularly in sensitive conversations, that can create significant cultural and reputational issues internally.
So, this is really a reset moment for employers.
It definitely is. The key takeaway is consent needs to be informed, specific, and obtained before recording occurs. It cannot be backdated, and where it has not been obtained, particularly for audio, the safest course is to stop and reassess. So, what about clients or visitors who come into the workplace?
This is really often overlooked. If meetings are recorded, external participants must also be aware and consent.
So, signage alone may not be enough.
That's right. For meeting rooms, the best practice is verbal disclosure at the start of the meeting, provide written notice in meeting invites, and also provide the option for them to decline. Let's say a business records client meetings for training purposes.
That can be done lawfully, but only if the client is clearly informed and consents. If a client later discovers they were recorded without consent, that can create legal and reputational risk.
And this all feeds into employment disputes as well.
Yes, if surveillance is used in disciplinary action, the way it was obtained becomes highly relevant. Unlawful recording can undermine the employer's position, even if the conduct itself was problematic.
So let's bring it all together. Video,
Generally permitted with notice and purpose.
audio.
High risk and requires consent.
What about meeting rooms?
Typically involves private conversations.
Policies
Critical, but they must be specific and transparent.
And importantly, consider employees, clients, and anyone else entering the workplace. Because surveillance is not just a legal issue, it is also a trust and governance issue. If you're reviewing surveillance practices or unsure of where your obligations sit, it's worth getting advice before implementing or relying on recordings.
Follow Legal on Demand for more conversations on employment and commercial law. If you have any questions or would like us to explore certain topics, please contact us via our website, maguirelegal.com.au.
Thanks for joining us on Legal on Demand. Practical law, real decisions on demand.